Hello, everyone. My name is Paige Barada, and on behalf of US Law Network, we welcome you to this US Law Remote Learn webinar. US Law Remote is a series of virtual offerings ranging from our podcast to roundtables and more. If you'd like to learn more about these offerings, I will post a link in the chat with more information. Today's webinar topic is labor and employment landscape changes. Since this session is set up as a webinar, your microphone and camera are turned off, but you can use the Q&A feature to post any questions and comments, and our panelists will answer them as they come in. Now I will turn it over to three of our member attorneys and allow them to introduce themselves.
Hey guys, my name is Jeffrey Hendrickson. I'm a partner at Pierce Couch Hendrickson, Baysinger and Green in Oklahoma City. I do labor employment with a side of medical malpractice defense, and so I'm glad to be here with you today.
Hi, everyone. My name is Jessica Farley. I'm a partner at Snyder, Burnett, Egerer in Santa Barbara, California. I do labor and employment as well, mostly employment, not so much labor. And I have a side of premises liability.
Hi, everyone. My name is Katy Alsobrook, and I'm a partner at Dysart Taylor here in Kansas City, Missouri. I also do mostly employment, labor a little bit, and some general insurance defense. And I'm excited to talk to everyone about the changes in the labor and employment landscape that we are seeing under the new administration.
Yeah, so as Paige said, if you guys have questions, which we certainly encourage, please ask those in the chat. We are monitoring that while we'll be talking, and we will respond to those as they come in. I think all three of us are used to doing presentations where everybody is actually on the screen and actually talking to us while we're doing it. So we certainly would love questions. We've got some great topics that are teed up today to go through, but certainly, we're not going to cover or can't cover all of the possible nuances involved in each of those. So your questions are helpful sometimes to describe particular issues that you're facing, or to point out some nuance that we can touch on a little bit further. We're going to be talking mainly about four areas, and then we also have some miscellaneous topics depending on how quickly we're able to move through it. But we're going to be talking, as you can see, about the changes at the National Labor Relations Board. This mostly has to do with guidance from the board that rescinds previous memos that were issued and therefore changes the interpretation and the scope of some of the provisions of the National Labor Relations Act in some pretty significant ways. We're also going to be talking about changes to, I suppose, the Equal Employment Opportunity Commission with respect to what the EEOC is focusing on in terms of what they're looking at for private employers, the types of discrimination that they seem to be most interested in, and kind of what you all need to be aware of when it comes to, making sure your company's practices are, done in such a way as to not draw EEOC scrutiny, but then also, done in such a way so as to comply with existing law, obviously. And then we'll also be talking about kind of the increased scrutiny that ICE and, in some respects, the Department of Justice are applying to employers that rely heavily on immigrant labor in terms of raids that are being conducted on workplaces where it is known or suspected that some of the workforce may not be in the United States illegally, and also kind of how to handle a raid if it happens, kind of things to look for. And then lastly, we're going to be touching on the development of artificial intelligence and how it applies to the workplace. There's been an executive order from the current executive branch that seeks to broaden and encourage the use of AI in the workplace, but what comes with that are some attendant responsibilities that the employer has to make sure that today's laws are still complied with, regardless of the increasing reliance on AI that I think we are probably all experiencing. So, you guys have anything else to add to that little summary there, or are you ready to jump right in?
It was a great summary, Jeffrey.
Thanks.
It is a great summary. I think the thing to keep in mind with this is that these are landscape changes. And so we're talking very broadly about these topics, and just wanted to echo, as Jeff said, that if you all have any specific questions about how these might be applied, then that's something that we can try our best to address. But these are just things, sort of issue spotting, bringing these things to your attention so you could have your antenna up because things that we've previously all been working on as assumptions aren't necessarily going to be the same moving forward. And so keep your ears open for those changes.
Certainly, and Bob Brooks in Rhode Island might be joining us at some point too. I think he might have had something come up, but he may be hopping on here, and we'll be able to grace us with his wisdom as well. But with that, we will jump right in. We're going to first be talking about changes at the National Labor Relations Board, and I think Jessica's going to take the lead here, and then we will kind of follow on with our commentary. And then, as we've said already several times, your questions are appreciated.
Sure. So I think, especially I practice in California, and non-competes in California and the private sector are pretty much unenforceable. And that, that will probably remain the same for, a lot of private employers. But the NLRB under Trump's administration is going, is reversing course on what the Biden administration did. And so whereas the Biden administration had an emphasis on non-competes, on restricting non-competes and restricting the use of stay or pay agreements in the workforce, which basically says if an employee wants to be reimbursed for some of the expenses that they've incurred in the course of their business relationship, they have to stay there for a certain amount of time because the employer has invested in them. And so before they can be reimbursed, they have to stay there. So Biden said, we're going to restrict those types of agreements. Well, under the Trump administration, the NLRB has reversed and said that they're not necessarily going to restrict those stay or pay agreements to the same extent. They are not going to restrict the use of non-competes to the same extent. And so that is definitely a shift in how the NLRB is working to, keep an eye on the relationships between employees and employers in the federal context. And, there is, I think it was the FTC in January put in place sort of a committee to say, while we are reversing course in these ways on what the Biden administration was doing, we are going to keep an eye open for particularly egregious non-competes that might trigger some violations of antitrust clauses. So there is some balancing there. It's not going to be a Wild West rodeo where, non-competes are enforced without any consideration of antitrust laws and broader considerations like that. So it does seem like they're trying to strike a balance there. And then same thing, the NLRB has rescinded memos that the Biden administration had put out as guidance regarding outlawing non-disparagement and broadly worded confidentiality clauses in settlement agreements. So they're kind of taking a step back from that and giving the parties a little bit more leeway to construct those severance agreements and employment agreements how they wish.
And go ahead, Katy. Sorry.
Oh, I was just going to say, and as always, I mean, you're going to have to compare what's happening nationally with what's happening in your specific jurisdiction. Like I'm sure Jessica can tell us lots of interesting things about how things work in California versus just about everywhere else. But it's important to keep both of those things in mind.
Absolutely. Whenever we go to conferences where I have the opportunity to talk to attorneys who practice in Texas specifically, just like, wow, that's a lot different. Non-competes have always been treated differently between those two states, but now we have this additional layer of change.
Do you all feel that, when there is kind of shifting sands from the federal government with respect to how they're going to look at these, that states, and obviously there are philosophical components to why you would want these or why you wouldn't. But do you feel as though states tend to the extent that their laws change as quickly as the federal government's laws change, or probably in a lot of ways quicker, follow on to kind of where the federal government is headed with respect to how things are interpreted? Or, do you sense that it really is more focused on each state's political climate and what they value in terms of being able to, how the market functions in that area, I guess?
I think I would say that depending on how a state is already leaning and, what its tendencies are, if they are, pro freedom of drafting these agreements and they don't want the restrictions that the Biden administration was placing on those agreements, and they're going to use this as justification and lean into it to sort of accelerate the pace of changes in that direction. But I think places like California, this isn't going to make too much of a difference in the private sector. Obviously for public sector, that they're going to be looking at the NLRB for guidance regardless.
Bob, we're talking about, and good to have you. We're talking about changes at the NLRB and principally with how the Trump administration has rescinded various memos that the Biden administration had in place, and kind of what the impact of those are. And so if you have any thoughts or kind of want to jump in, certainly welcome and glad you're here.
Well,
Or introduce yourself to everyone.
Yeah, or introduce yourself too.
Yeah. So I'm Bob Brooks. I'm an attorney in Providence, Rhode Island at Adler, Pollack and Sheehan. Been participating in U.S. law conferences for longer than I care to admit to. But what I thought, back when the Biden administration, when the prior general counsel started to get what I think was really aggressive about using the National Labor Relations Act as a weapon against employers and as a way to kind of push employers back, just in terms of the tools that we employment lawyers use daily, to protect our clients. That was really an interesting development. And what I see the Trump administration, at least in this case, doing is kind of bringing things back to status quo, bringing the kind of playing field back to equal. Because what I experienced after the general counsel imposed, restrictions, let's say on confidentiality provisions in severance agreements, or limiting broadly written releases of claims, that even plaintiffs' attorneys had trouble trying to figure out, what the landscape would be and how to handle the situation, because, now they had clients that they thought in the past they were getting a comprehensive settlement for, and wrapping up all of the issues that may have existed, all the potential issues out there that this plaintiff might have thought of. And now they had a situation where they were getting a settlement, but their client was now asking, well, can we still sue for this? And can we still go after them for that? Where the plaintiff's attorneys were now kind of really struggling, as well as management attorneys, on how to handle this. So I think what the Trump administration has done with the acting general counsel rescinding some of those memos that were put out there to kind of restrict these things is kind of, re-leveling the playing field from an employment law standpoint, which I think really could help both sides, I believe.
Yeah, I was going to say, do you sense that it really is beneficial one way or another? Or if it sounds to me like, and I've had that experience too as well, especially in the context of trying to put these things together, balancing, what Oklahoma requires. And that's the majority of where I run into this issue is, how it exists under Oklahoma law relative to how it does under the, federal laws. And so I think you answered it, but I don't know if you had a sense as to whether it was beneficial for one side or the other, or really it was kind of a rising tide situation.
Well, I think if it benefits one side, I believe it's the employer's side. But as I said, it did prove difficult for plaintiffs' attorneys, who, we're trying to wrap up, they've been litigating a matter a year, 2, 3 years, whatever it might be. Now it's time to wrap up the case. And, an educated plaintiff is reading the newspaper, reading the magazines, doing their own research online, which sometimes plaintiffs tend to do. They start asking questions. Well, is my case really over? I think that's the difficulty that the other side, that the employee side was having with some of the things that the NLRB was doing.
Yeah, very good. Okay. Anybody else are there any particular? I think we got one question in the chat, unless my pop-up is not working correctly here.
Oh, am I
that was
not
Cheryl. Sorry.
Okay.
That was Cheryl. Thanks. Submit thoughts and questions. So there you go. Any other kind of thoughts on this first topic with respect to the NLRA/NLRB, guys, or are we ready to move forward?
We can move forward.
Okay, sounds good. And certainly also, folks listening, if you have a question or a thought about a topic that we have moved on from, submit regardless. We can go back.
Did you talk about the non-compete aspect to this?
Very briefly, but if you have additional insight, please.
No, what I would just say on that piece of it, that was really one where the NLRB was, and we've seen this, the NLRB, other federal agencies really tried to outlaw non-competes. Now, non-competes have always been an issue that has been handled state by state. Each state's law might vary a bit about, what's a protectable interest, how long is too long for a non-compete, how broad can the non-compete be written. Some states, restricted in terms of geography, and then suddenly federal agencies in the NLRB were now outlawing non-competes. And I think that this in particular, so overruling this particular general counsel memorandum was really, I think, a step toward assisting business, going back to a situation where businesses could legitimately protect themselves against the actions that employees with knowledge of the company's business, knowledge of trade secrets, knowledge of customer lists, could then just take all that information under the decisions that the NLRB was making, and just move on to take all that information to benefit themselves and benefit other employers. So I think that this was really a step by the Trump administration in this particular instance to protect business interests and to really, I think, make sure that in situations where the employer is investing in the business, investing in inventions and intellectual property, that those investments are being protected.
Yeah, and very good. And as the point has been made several times, I mean, especially with what Bob was just touching on, but with many of these areas, I mean, I think that the comfort that a business can take away is knowing that at the high top level, that there is sort of a change philosophically in how these things are being approached. But certainly, one of the great benefits of U.S. law is that we're in every state or almost every state. Because, at the bottom level, as Jessica pointed out earlier, a lot of these changes are not going to necessarily affect exactly how, one particular state does it or not. And there are certain states that are known, kind of just classically as having a all or nothing approach to this issue. And so, before taking, significant amount of guidance from what the NLRB is doing, which is obviously very important, there is going to be lots of state law that applies. And, with the way our webinar is set up and the fact that our 4 presenters are in, 4 different states, we are going to be describing things kind of at the highest level as they are going to be applied to everybody. But certainly the caveat of know your state's law and talk to, counsel in your state that's knowledgeable in that area is always going to be, an important caveat because, these issues may percolate quickly at some state levels. Oklahoma tends to react to these things somewhat fast. We kind of do things, year by year around here. It's not going to happen that way in every state by every means. So anyway, okay. So if nothing else, let's proceed. And like I was saying, if you have a thought or a question about a topic that we have covered and moved on from, submit it anyways, and we will be happy to go back. We have plenty of time to do that. So we're going to jump now into changes at the EEOC. Hold on a second. Sorry. There we go. And as with this one's a little bit different in the sense that there's not quite as much in terms of legal or quasi-legal action being done specifically that is applicable to private employers in the way that the NLRB releases guidance on memos, and the executive department, the executive branch releases executive orders that directly address those topics. But here the focus is going to be more, and Katie's going to lead us through an emphasis on the way that the EEOC is looking at investigating and kind of what they're focused on, because there has been a change, it seems. Some of that makes the news, especially with respect to the subpoenas that have been sent out, the requests for information that have been sent to some pretty large law firms. Have been in the news in the last few months. But I think we can kind of draw a lot of information from those about what we can do at our various institutions about how to govern ourselves and what we think the EEOC might be looking for. So, Katy?
Yeah, so everyone, again, like Jeffrey alluded, you've probably seen a lot of stuff in the news about, in addition to Donald Trump's executive orders, changes that have occurred at the EEOC. In January of 2025, Donald Trump appointed the current commissioner, Andrea Lucas, as the new acting chair of the EEOC, and he removed the EEOC general counsel. Both of these actions were pretty typical of a new administration coming in. What was not typical, or what is not typical, is that President Trump then removed Commissioners Jocelyn Samuels and Charlotte Burrows, two of the three Democratic commissioners at the EEOC. And so there is currently no quorum at the EEOC. And the impact of that is that they do not, well, you need a quorum to be able to vote on rulemaking, to rescind previous or prior guidance, and to issue new policies. So it's widely viewed that the actions of removing these two Democratic commissioners was meant to kind of pave the way for, and aligns with, some of these other executive orders that we have seen coming out of the Trump administration, which specifically target DEI, diversity, equity, inclusion, or DEI. I will note that I think a lawsuit has been filed by, I think it's Jocelyn Samuels back in April, challenging her removal prior to the end of her term. In the history of the commission, there haven't been commissioners that have been removed prior to the end of their term. Now, the president or whoever is in office can appoint people as availability comes up, but they haven't been removed in the middle of their terms previously. And so again, this aligns with President Trump's executive orders that I'm sure everyone has seen regarding DEI initiatives, specifically programs that seem to favor certain groups, minority groups, over non-minority employees or applicants. One of the cases that has just been argued recently before the Supreme Court is this Ames versus Ohio Department of Youth Services. And in that case, it was a case of what is sometimes referred to as reverse discrimination, or discrimination where the person alleging discrimination is not a member of a minority group, but is a member of a majority group. In this instance, the plaintiff was a heterosexual woman who was alleging that she was passed over for promotions in favor of a lesbian woman and I think a homosexual man whom she argued were less qualified. In the past, there's been a split in the circuits about this burden or the standard that you have to meet in order to show discrimination when you're a member of a majority group, or when it's one of these what we refer to as reverse discrimination claims. Based on the oral arguments that occurred, I think it was back in February, we think that it is likely that the legal standard will change, and there will be no higher burden to establish discrimination in one of these reverse discrimination claims, meaning that you don't have to go through an extra step to establish facts to support pretext that that you were discriminated against, which is something that has been the case in the past. What was interesting, I know that during the webinar that they had a couple weeks ago, someone raised the possibility that this will, like, if in fact what we think may happen, and there's a change to this legal standard, the impact that may have in the future is just kind of a lower standard to be able to establish discrimination across the board by any group or class. So that's something that is going to be interesting to watch and monitor the impacts if that is in fact what happens in this case. Again, the in line with many of the executive orders that we have seen, the EEOC now seems focused on individual claims as opposed to systemic discrimination or historic discrimination, which has in the past or up till now been a large focus of the EEOC. We'll want to keep an eye on what happens with this lawsuit that was filed by Commissioner Samuels, who's alleging that her removal was unlawful. But kind of in the interim, what we expect to see is, just a focus on enforcing these anti-DEI executive orders that we've seen come out of the Trump administration. You guys have?
I think a big takeaway from that, the Ames case and kind of where it is likely headed, is just the point that when you take that concept and kind of the way they're going to rule, which is most likely going to say something to the effect of, this statute says this. It says you shall not discriminate on the basis of these protected classes, and there's nothing in the statute itself that has ever said that there was some sort of different requirement. If you happen to be a member of the majority, they'll say, I think, discrimination is discrimination regardless. And that's what they said, if you're drawing lines between this case and the Bostock case from several years ago that read sexual orientation and gender identity into the term sex in Title VII. I think they'll say the same thing. Say, we don't make any differences for what class you happen to be a part of or what group you happen to be a part of. If you're a group and you can establish that there was discrimination that occurred to you, then it doesn't matter, which group you were a part of. And I think the line to draw from that, onward is when it comes to DEI and when it comes to programs that are like that, is not that in and of themselves that those programs are unlawful. Not that in and of themselves emphasizing diversity is unlawful, but the distinction is when you start making decisions that are making actual decisions that have legal impact, be it hiring, firing, discipline, job transfer, pay. When those decisions break down purely on the grounds of diversity, so you say we're going to hire this candidate and not that candidate, and it's because of this, probably not that blatant so many times, but to the extent it is, that's when the law is going to apply. But if your general philosophy is, we have philosophically an approach to hiring, for example, that we make sure we interview at places where we think it's more likely that we'll have a set of applicants who are maybe of a minority group just by virtue of where we're interviewing. And you do that with kind of a broad scope so that you ensure you're sweeping everybody in, but your goal is, expand the number of people we're interviewing. And I'm using that kind of narrow example. That's not unlawful. And the EEOC is not, can't speak for them, but insofar as you apply the sharp edge of the law to something like that, that's not unlawful. And so broad goals like having a diverse workforce, having an inclusive workforce are not the problem. It's the problem is when those decisions become, or those goals themselves become the decision-making tool that you use to do one thing or another. And that's when I think you're going to get a much closer magnifying glass on those decisions from the EEOC. And I do think generally, especially after this Ames case, of course, it could come out the other way, although the oral argument would be very surprising. I think that's how the federal courts are going to start looking at it too. They're going to take their cues from what the Supreme Court says, and I think that will trickle down pretty quickly through the language of that case into the litigation that we face in that area. So, I think that's just a beneficial thing to think about when it comes to how do we still push forward with goals that we think, and I think a lot of people agree, have genuine benefit and value in a climate where it feels like maybe we're sort of being pressed away from that. How do we do that in a way that still meets our goals while being respectful and appreciating that the way it's going to be viewed from the top level is looking a little bit different. So
I think being more explicit about why the candidates that you're choosing and why the decisions that you're making are what's in the best business interest of the company, why the person is the most qualified, is something that everyone needs to be more aware of. Is just being more explicit in that decision-making process.
Right. I think that's right. And to Jeffrey's point, the executive orders are not, they do not change statutes. They do not change the law. They give us an indication, and these other changes that we've been talking about give us an indication of what a certain administration is going to focus on. However, the law is what it's always been. And like Jeffrey said, you can't discriminate in these employment actions on the basis of someone's membership in a protected class. And that's always been the law, or not always been the law, but that's been the law for a long time, and it will continue to be the law. But we will have to see how some of these decisions impact how the law is applied. But another thing that was also pointed out in the recent webinar is, I think we have to be aware of all of these changes, the landscape and what's happening, where we have to be cognizant of the differences between the federal law and what's happening there and the laws in our own jurisdictions, which we here represent, kind of the span of the country here from the East Coast to the West. But we also have to be mindful that, it's a pendulum and it swings back and forth. And, you know, we certainly don't recommend anyone go out and change everything that they're doing dramatically. Like Jessica and Jeffrey mentioned, you don't, you know, the values of your companies don't fundamentally change because, you know, there's a new administration or changes in the law. You just have to be more aware of, I guess, appearances and how you justify those values in practice or document them.
You know, one of the ways that we can tell what a particular administration is up to is to look at the individual websites for the federal departments that engage, you know, in protections, labor and employment law protections. So if you look at the EEOC's website, you know, Kate was mentioning earlier, you know, removal of board members and not having a quorum of board members. But at the same time, I looked at the EEOC's website last night. There's a section, what should you know about DEI related discrimination at work? And the questions there, that was, you know, I printed it out, it's 16 pages long, but there's question after question that's really related to what a person who's not in a minority group should do if they feel as though they're being discriminated against because of an application of a DEI policy. Now, I juxtapose that with other things I saw on the website, which were, you know, most of these federal departments will have a news section. And the news section points out, you know, the different things that the department's up to, you know, settlements with an employer that's been found to have engaged in discrimination. And the news section and all of the settlements all dealt with traditional sorts of cases involving discrimination, you know, based on race, based on sex, based on disability, where then when we go back to this DEI section, it seemed to be almost reminding non-minority employees that they have rights too. So I see, you know, what I see as a landscape where all the traditional types of protections will still be pursued, that will still be defending cases brought by those who believe that they've been discriminated against because of their membership in a minority group as opposed to a majority group, or discrimination based upon, you know, sexual harassment or sex or disability. But now I think what these changes, you know, these DEI or anti-DEI initiatives, it's waking up other groups of employees to the protections that exist under the law, and they're being educated by that. But I still, so far, the cases I see, the new cases, are still the traditional sorts of discrimination cases that, you know, Kate and Jeffrey and Jessica and I are all used to defending, which are, you know, cases brought by those in minority groups who feel as though they need to be protected. So I think it's interesting that, you know, the Trump administration seems to be going out of its way to say to other groups of employees who have not traditionally been in groups that have brought these claims, hey, you're protected by the law too. But so far, in terms of the practical results, I don't see that there's this growth of other kinds of cases that are being brought, at least not so far.
Yeah. We actually just got one in about 2 or 3 months ago that was a reverse discrimination claim, and our briefing on it was really good up until the Supreme Court's probably going to change the standard that we use. So I'm sure we'll hear about that in an order, would be my guess. One of the things I think is also going to be interesting to watch for, and I don't know if we'll be able to see it just because my general understanding is that the EEOC is one of the agencies that has suffered a significant number of cuts to its number of employees. But I think one other thing I'd be interested to look at, and I would guess that there is no way to know this at this point, but if there's an increase in the number of cases that over time the EEOC themselves takes over from private individuals, and especially if they feel like they have a case that, you know, is maybe one that could be a potential news making case, or if they start to look for those kind of things, how much the agency itself gets involved in becoming the actual plaintiff against a defendant alleging a claim in this area. But like I said, I'd be surprised if there was any information on that at this point. It's only been 5 months, so many more to come, I'm sure. Okay, well, any other thoughts with respect to our friends at the EEOC? All right, well, we are humming quite along. We're 45 minutes in or so, maybe a little bit past that. So let's get to our next two topics. We're next going to talk a little bit about skipped one too far, sorry. The increased scrutiny by ICE on employers that rely heavily on immigrants to form a base of their employee group, and kind of what to do in those scenarios. Bob, in full disclosure, we were talking beforehand about, when we were kind of planning, and between us three, there wasn't a lot of, hands-on experience with navigating an employer through actually being called and being said, hey, we've got ICE coming or they're here. Is there anything in that area that you have specific experience with? If not, we've got plenty of stuff to talk about, but just curious if there's anything in that area that you had specific experience with in terms of talking an employer through, getting notified that ICE was coming or ICE showing up at the front door or what have you.
It was interesting. Back in the first few weeks of January or after January 20th, I did get calls. I'm in New England, and so there are still a number of textile manufacturing firms here in New England. And so we had a number of clients in that space who were receiving information from other textile manufacturers that ICE was coming, ICE is on its way, so to speak. And so we got calls about, hey, what do we do if ICE comes and shows up at our door? And so we gave the advice on that, that you can ask for specific information as to whether they're pursuing a specific charge, or that they're investigating a specific situation. Do they have a warrant to be on the property? Usually a court will issue a warrant, and it'll be very specific as to the area of the company that is subject to the investigation. It might be limited to a department. They might be limited to specific employees. And so we started giving that advice on how to respond if ICE shows up at your door. And then ICE didn't show up at any of the doors of our clients, at least so far that we know of. There have been, I think in those cases where ICE shows up, they do a great job of notifying the news media and getting a lot of publicity around what they're doing and the actions that they're taking. But I see a lot of concern, a lot of steps being taken to learn what to do if ICE shows up. But I haven't seen that many circumstances where ICE has actually knocked on the door to come in and to inspect the workplace, or to line up the employees and determine whether they were in the country legally. At least not yet.
Yeah. Well, I think the general, whether they have come knocking on the door or not, the general prescription, and frankly, we were talking about it beforehand, and it tracks a lot of what the general advice is. If a police officer comes to your door and has a warrant, I mean, you're entitled to look at it. You're entitled
What
to
does it say? Right.
You're entitled to see what they're allowed to look at, and you're entitled to, resist. I mean, that gets complicated, but if they begin going beyond the scope of their warrant. And so I know one of the areas in this, one of the specific issues in this particular area has to do with the kind of warrant that is presented. You can have warrants that are judicial warrants, and those are typically enforceable as long as they appear on their face to be so. and entitle the officers who are there to come in and entitle them to take what is described and look where they are allowed to go. But you can also have these things called administrative warrants or immigration warrants, and those do not necessarily entitle the officers to enter or do precisely what a judicial warrant would. And so I think kind of at the baseline level, starting with, calling your attorney if they're there, if somebody you get notice that they're on their way, but then also when they are present, knowing that, you have rights, that the company has legal rights to look at the documents that form the basis for the government's entry onto your property. And in some instances, if there are examples, and the examples would be, too many, I think, to list, but there can be situations where you can say, now, leave it up to the particular situation as to the risk that's run by doing this, but you could say, no, you can't come in. This warrant doesn't contain a judicial signature. It doesn't contain a description of the property to be searched. It doesn't contain, you're trying to enforce it outside of a statutorily required time period. So knowing and, having the resources to tell you what you would be able to do in response to what you're presented, but knowing that you have the right to ask, you have the right to see before, and it's not just a question of you can open the door and that be that. I mean, I think is a good starting point with respect to dealing with the federal government to the extent that they are actually showing up and attempting to execute on something that they claim to be an official government document with the power of the state behind it. So those are my thoughts on that. All right. I would remind everybody that the chat box is still open. It's feeling rather lonely. That being said, we are also plowing through our topics here and doing an exceptionally solid job of using our time to do so. So I think the last topic is probably one that would be a good one to carry us through on, and this is going to touch on an area that is very easily discussed and put into very small corners and boxes, and one where I think we all know where the future is headed with an incredible amount of clarity, and that is artificial intelligence. I was being facetious. Obviously, nobody has any idea where AI is headed, but there are areas that we and you all as employers need to be thinking about AI in a number of ways that go well beyond your legal requirements. It is coming for many components of many of the ways that our businesses do what they do. But one thing that I think we all, and I kind of want to defer to Jessica here a little bit too, but one area that as labor and employment attorneys we see is what is going to happen in the next 5 to 10 years when what likely will come to pass is that there are probably going to be a number of jobs that are going to be replaced by artificial intelligence. Maybe not entirely, not in full, but maybe so much of one particular job would be or could be automated that you might, as an employer, get to the point where you're having to make decisions about job terminations, about eliminating job positions that in the next 5 to 10 years are going to be able to be accomplished by AI more quickly and likely better than a human being can do it. And so obviously with the caveat that there are a lot of different directions that this could go. I was listening to a podcast a couple of days ago that anticipated that in 3 years AI would essentially have developed the ability to take over most of the functions of day-to-day life. That's this particular philosopher's view on it, relative to a much broader scope. But I think we can all agree that there will be changes, and that those changes are going to impact job decisions. And so keeping in mind, I think the fundamental responsibilities of a business when it comes to laying employees off, when it comes to furlough employees, when it comes to making those decisions is crucial, because just because we think there is this coming kind of AI revolution that is going to end up taking a number of job positions away, that doesn't mean that, doing so without paying due respect to discrimination laws and things barring a company from just simply acting because they think the financial interest is so beneficial, has to be discussed. So Jessica, I kind of want to tee that up for you. And if you can give us your thoughts on that, and then I've got a few more of my own, obviously.
Let me just check ChatGPT real fast and I'll get back to you.
Yeah, perfect.
Yeah, no, I mean, what's really interesting is that I think we all know how quickly AI moves, and certainly faster than we can regulate it. And so the Biden administration had plans in place to make sure that the way that we are using AI is subject to certain standards of quality control, that we are protecting certain groups from the misuse of information, whether it's accurate or not, that we're using AI in a responsible way to
Whatever you're about. I think AI got you.
Uh-oh, yeah.
You're about to give
our
us
workforce.
That's scary, I have to say. That's scary.
And so, Trump, the Trump administration has come in and is trying to basically see that quality control as barriers. And so they enacted this executive order entitled "Removing Barriers to AI and to American Leadership in Artificial Intelligence." And so their goal is to make sure that we are moving quickly with how we're implementing AI without necessarily having the safeguards in place that the Biden administration was envisioning. And so it's really not clear exactly how this is going to play out because, Biden had these goals of putting safeguards in place, but again, they were, sort of aspirational in a lot of ways. And so likewise, Trump has come in and said, well, let's remove those barriers. We're going to review what the Biden administration's goals were, but what does any of that mean, right? It's a lot of aspirational language, and the goal clearly of the Trump administration is to allow AI to flourish, if we're reading between the lines. So just as the executive orders regarding DEI at the beginning of the year were sort of aspirational by the Trump administration, and now we see, as Katy mentioned, how Trump, is removing members of the EEOC to, presumably enact those aspirations. I think that that's what we can expect moving forward, is that there's going to be some personnel changes, and in an effort to promote AI. It's just not clear exactly what's that going to look like. But we do need to keep our antenna up to make sure that as our clients, as our businesses are developing AI, that we're keeping the actual human beings who are employed in mind, and making sure that we're not, inadvertently discriminating against certain groups of people who are perhaps less skilled, less skilled, but perhaps members of a certain socioeconomic status who are perhaps more easily replaceable depending on the industry. So that's what I have.
Yeah, no doubt. I mean, one thing that I was thinking about in this particular context, and again, this is probably more of a conversation for our webinar in 2026 or 2027. When we start to see really what is going to happen, because so much of what we know or think about AI, I mean, here's the deal: people who are developing AI, they don't even know how it works. I mean, they don't even know how AI has happened in some respects, and how components of what they themselves have developed have gone on to develop or figure out how to do things that they didn't even know it knew how to do it. And so that's kind of the foundational point of, we don't know where this goes, which is the people who are designing it in some respects, they don't know where it's headed either. And so anticipating what it's going to do to the workforce in the next 5 to 10 years is almost impossible. The one thing we can say, though, is, as we were talking about on the EEOC topic, the law is still going to be the law with respect to what binds employers. And so I was thinking about this before we got started in the context, for example, of performing from an employer standpoint a reduction in force. We have clients, I have clients who tend to, or in the past have done those in kind of a haphazard manner. They just sort of heard the term reduction in force and they sort of kind of over time let a bunch of people go and called it a reduction in force without having actually done the strategic planning, the evaluation, the calculations, and the real basic framework for doing a employee event like that, that would insulate them, or at least, give their defense counsel, if they ever got sued, a real good set of evidence to rely upon about making those decisions. And, I think about that in the context of where could this be in the next 5 years? Well, we could have a number of employers that are having to make decisions about, hey, this job is pretty much a job that can be done now by AI. But does that mean that, because we think we can do that and we can purchase a system that enables us to do that, that tomorrow we can just tell this whole department, hey, it's time to go? The answer is no. You can't do that unless you want to get sued by all of them, for disparately impacting, a number of employees that fit within whatever group you think is about to be replaced. And so at the bottom line, it is, remember that the laws that have always applied to these types of employment actions will continue to apply regardless of the impact that AI has. And if it ends up being a significant one, it still requires a measured, meticulous evaluation of what you want to do, what needs to be done, and to what extent it needs to be done before you just kind of go along with the general rush of the times. And so I think that's just kind of, at this point, the best perspective advice we can describe in this area is that regardless of how fast things develop in this part, the law runs alongside it, and due attention has to be paid to it.
I think that might be a great place to wrap up, unless anybody has any questions in the chat box, or unless any of the panelists have anything to add without going too far over.
I do not. I think this is excellent timing.
Yeah, it was very enjoyable to at least talk about these topics. And obviously, they're all very complicated, all moving, very swiftly, and the developments will continue, and obviously we'll be keeping track of them.
Yeah, absolutely. It was great to present with you all, and thanks for everybody that joined us. As just a plug, one of the best things about US Law, and one of the reasons to continue using the network, is because we are able to describe these things at kind of the high level. But, at the basis, if you need an attorney in Rhode Island, don't call me. Call Bob Brooks, because he knows the details of what's going on in Rhode Island. Same for Katy in Kansas and Missouri, and Jessica in California, and me in Oklahoma. And that's what US Law can provide. And so it's great to be able to host this with you all and get to kind of talk about it at that level. And there's going to be no shortage of information for these webinars in the future, and we look forward to doing another one soon.
Well said. Thank you.
All right.
Thank you, everyone.
Yeah, thank you to all the attorneys. Thank you to everyone for participating in today's webinar. If you wish to participate in future roundtables or webinars, please take a look at the link I've just posted in the chat. Thank you.
All right. Thank you. Have a great day, everyone.
Bye.